afternoon. Thank you for joining us for our second Lunch and Learn in this series with Mark Greenberg. My name is Megan Moschel, and I'm moderating this program today for the Alternative Dispute Resolution section, of which I'm the chair of the CLE committee and member of the Executive Council. I've also got Christina Blunt here today. She's our incoming CLE chair, and she is helping out with moderation. If you are not a member of the Alternative Dispute Resolution section, I encourage you to join this dynamic group. Our membership is comprised of mediators, arbitrators, and attorneys who participate in various forms of dispute resolution. The Alternative Dispute Resolution section offers valuable resources and networking opportunities with others who are leaders in the field of ADR. We'd also like to thank our annual section sponsors, Miles Mediation and ADR Notable. As to some housekeeping matters, if you wish to ask questions of the speaker or need technical assistance, please utilize the chat feature. The presenter will answer all questions at the end of the program, although they may answer some questions throughout. You'll need to log into the Florida Bar Members Portal to enter your own CLE credit. Today we have How to Start and Finish Strong in Mediation with Mark Greenberg, and the CLE number for this program is 260206-4N. I'll repeat that at the end of the program and put it in the chat. And it qualifies for one general CLE credit and one ethics credit. This course also qualifies for CME credit, which does not require a course number as it's self-reporting for the purpose of renewal of mediator certification with the DRC. And I'll put that information in the chat as well. Now, I would like to introduce our speaker, Mark Greenberg. Mark is the president of Breakthrough Mediation. Before becoming a full-time neutral, Mark tried over 100 cases to verdict, representing both plaintiffs and defendants in both state and federal court. His background spans first-party insurance coverage, third-party liability, personal injury, construction defect, contract subrogation, and HOA-COA matters. He now helps attorneys and clients find peace in the resolution of contentious disputes. He's a member of the ADR section of the Florida Bar and serves on the Executive Council, and he's a current chair of the ADR committee for the Palm Beach County Bar Association. Thank you so much for being here with us today, Mark. Take it away.
Thanks, Megan. I appreciate that. And there's going to be some times in here today that I'll probably make a few mistakes and things may not be exactly perfect. I want everyone to recognize that that's how mediations go as well. And it's okay. You're not going to be perfect during a mediation. You're going to make what you think are mistakes. They may or may not be. And it's okay. Nothing. It's like if you're in trial, there's no such thing as a perfect trial, right? We all know there's always three presentations we give in any kind of court or other proceeding. The one we think we're going to give, the one we actually give, and then the perfect one that we give in the car on the way home. And mediation is kind of the same way. And as a small example, Megan, I need to update my summary to you because I am no longer the chair of the Palm Beach County ADR section. That was a few years ago. So obviously we have not changed that recently. We're going to talk today about how to start and end mediations well, and also how to deal with the really difficult personalities we can run into. And part of the reason for that is I find that personally to be the biggest challenge at mediation, which is how do you deal with the people who just don't seem to think that there's a weakness in their case or don't want to concede on anything? How do you work with them to have a productive mediation so that you can try to help everyone settle it? And if not, you're at least advancing things forward and everyone's crystal clear on why they're going towards a trial and haven't settled it yet. So that's going to be our general outline. I am looking forward to some of your questions that we'll deal with at the end. In the outline itself, I did notice a couple of small mistakes with the citations to the rules. Candidly, I think I used the version from 23 and not the most recent one, but we'll update that. Having said that, this is an intermediate level class, so we are not going to spend a lot of time on the rules and the specifics of it, but rather helping everyone here how to become better mediators and how to apply some of the skills that we have learned in class and over time. So we're going to start with, how do we set the foundation for a solid mediation? How do we start this out? And everyone has their own approach to what the initial way of doing it is. I'll tell you how I do it, and I'll give you some thoughts, analysis as to why. So to start with, especially since 95% of what we're all doing is on Zoom, I let the parties in separately and I separate them immediately so that there's no cross-pollination. Very few things we can do as mediators that'll get us in trouble, but the last thing I want is to have, and an individual who has an attorney sitting in the same Zoom area as the opposing attorney, and no one else is there. Because all that can happen from that is 2 months later, the individual says, "Oh, well, the attorney was telling me this, that, and the other thing," and the attorney's like, "I never said that." And all it's going to do is create a problem that is so easily avoided. So I create the breakout rooms, pop them in there immediately. Um, Megan mentioned housekeeping matters, and that's critical. Once I get the attorneys in, give them my cell phone, get their cell phone. Why do we do that? Well, it's nice to be able to reach out and talk to them otherwise. It's also good if they need to say or do something that they don't want to say in front of their client during mediation, they can always side text you. And that's such a great way of doing it. You get their personal contact, which is good for just future relationships, but also, hey, my client needs to keep hearing it. They're not hearing it. Let them tell you let them guide you as to what your client needs to do. Or, hey, my client's shutting down. We need to soften this a little bit. It's such a great tool for that. Um, Setting the expectations. One thing I think we've all heard in mediation is, well, I want to settle for what's fair. And I sit there and I have to stop myself from rolling my eyes because, of course, everybody wants to do what's fair. But fairness doesn't mean the same thing to everybody. And one of the things I found works well for fairness when someone brings that up is, fairness is like art. Beauty's in the eye of the beholder. And that seems to resonate well with people. They kind of just pause and look at it and realize, yeah, I can see how some people like one thing, some people like something else. And it may not seem the same for both sides. So there's a small idea of how you can kind of just deal with that fairness thing, but I like to deal with it up front. And I'll tell you in a moment when that usually gets set early on. So after I've gotten, everyone's numbers, and I usually ask the attorneys when their clients aren't there. So, because some attorneys don't want their clients to have their own cell phone numbers, I don't really care. Um, we're gonna run in. Oh, and if you have any insurance people or anything like that, get their claim number immediately. And I tell them exactly what Megan did. Hey, before we jump in, just a couple of housekeeping matters. What's your guys' claim number on this? All right, hey, let me give you guys my cell phone number if you don't already have it. Here it is. Counsel, what's a good cell number for you or a direct number? Um, and no one ever says no. And they just give it, and then you've got it and you can keep track of them. It's also good if you're in a breakout room and it's taking a while. You can kind of let the other side know, hey, I'm still with them. Give it another couple of minutes. We haven't forgotten about you. Simple things like that. So the opening, a lot of people have questions about, how important is the opening? What should it be? And everyone's got their own opinion, back to fairness on eye of the beholder. What I've found works for my personality is I try to keep it short and I try to set some expectations within that. Um, I like to let them know that I'm going to challenge them during the mediation. I'm going to ask you some hard questions. I'm going to ask both sides hard questions, and I'm going to push you. And the reason is very simple. We know what plan B is. You're going to have a judge or a jury decide your case, and I've tried over 100 cases. I've never had a judge or a jury listen to only my side and not the other side. Counsel, if you've got a different experience, feel free to chime in. Of course, nobody does. So hey, they're going to hear the parts you like, the parts you don't like, and letting them know that when we're pushing them, it's not to be difficult, but simply, hey, I want you to look at this case through the eyes of the people who will decide it and not your own viewpoints. Because once you're at trial, you're losing. I don't see you lose control. I don't like to threaten them. I just want to be able to say our opinions don't matter anymore. It only matters what they see it as. And then we can circle back to that later on in the case and go, all right, what's a jury going to think of this piece of information? When they're telling you why they don't think, the other side's evidence is particularly important. If it's a car crash and there's a scratch on it, like, well, you can get hurt with or without a big impact, which is true. But what's the perception of a juror who doesn't have the medical and biomechanical expertise? How are they going to look at that? And then this is a little more individual. people don't know me. They don't know you guys. I try to be really vulnerable in the opening. I talk to them. The reason I became a mediator is, I went through a divorce and we needed three mediations to settle it. And I go through that a little bit. Um, and it's in part of it is to reinforce, hey, the reason we did settle is because we brought someone in finally who would push us, even though it wasn't fun, but also to let them kind of see a little bit of a human side. Because ultimately, I want people to be able to open with me and explain what they're worried about in the case. Not just the legal side, but how it's impacting them, good and bad, and what they really need out of it and what they're afraid could happen out of it. And it's much easier to do that if I can be vulnerable and admit to flaws and admit to trials in my life that 2 hours later, when I'm asking some of them questions like that, hey, how's this going to impact you? If you lose the case, how's it going to impact if you win? Um, it gives them a little bit of an opening to feel comfortable saying that. And then you can get some really solid information. So setting that foundation at the beginning by warning them that you're going to challenge and push them, and also being vulnerable yourself, then sets the stage later on for when you're doing both of those things with them because you've set it up straight and because people are feeling more comfortable. Um, Having said that, I do try to keep my opening down to a minute or so, a minute and a half. Um, I don't spend 10 minutes about my background. I don't spend 10 minutes explaining everything that's going to happen in the caucuses and all that other stuff. They've either been told that by their attorney or you can tell them that in the caucus itself. I just know when I was the attorney, I couldn't handle the 10-minute mediator openings. My ADD kicked in and I just lost my mind, especially when I've heard it 100 times. Um, so my preference is to keep it short and sweet. Um, I would say this, mediating cases is like anything else in life. You have to do what works best for you, and it's going to be different for everybody. It's not a one size fits all type of approach. So after we do in that opening, we get into the first caucus. Um, we're still trying to kind of handle the what's going to happen. You don't really know, they don't really know yet. Couple of questions that I have found helpful for people and that I will ask in almost every single mediation when we're separated is, what's your biggest concern about today? And I ask that to the individuals, not to the attorneys, not to, experienced insurance professionals, but to the people who are really the actual players in it. Um, no one ever refuses to answer that question, and you get some incredibly good information out of it. This is where fairness will often crop up. Well, I just want to get what's fair. Okay, well, let me circle back to that. All right, fairness is, in the eye of the beholder, different for each person. Um, but you'll hear from people like, I just want to get this thing done, you know, or I want to get it done, and go back to my life, or I need to do what's fair so I can get it. Well, like, you know, what they see as fair and yours might be a little bit different here, or sure, we can settle it, but you're gonna have to take, you have to take whatever they're willing to do on the other side. And well, no, I don't want that. Okay, well, you're setting that groundwork for a compromise because a lot of individuals who aren't sophisticated and perhaps have not been prepared by their attorneys as well as ideally, you're gonna want to start laying that groundwork for nobody settles for their worst day in court on the other side. If you're a defendant, 0 point in you paying, their highest best number they could ever get. You might as well go to trial, and if you lose, you lose. You're not worse off. Conversely, if you're only going to offer zero, plaintiff's not going to take it because zero to them now is zero to them at trial. Does not change things. So laying that out at the beginning can help. For the attorneys and for the, insurance professionals and people who are at mediation a lot, what's your biggest gripe at mediation in general? What do they not want you to do? And that'll get you a little bit of information on how they'd like you to proceed as best you can. A lot of times, especially with somebody who's got a personality or a negotiating type like I have, where I want to just get there and get it done and be done quickly, they're going to complain about the speed. You know, how many, I can't ask questions here so easily, but if I ask, how many people have said, God, they hate hearing how long it takes to get a mediation done, or the mediator's just trying to run their bill up? Probably almost all of us. Um, I like to address that at that point right away and just say, you know, it's kind of like buying a car. If you go in and you're buying a car and you find the car you like, and let's say the car is 50 grand, they're asking, and you go up and go, I'll give you 44. And the salesperson instantly goes, deal, without checking with anyone. What are you going to think? Yeah, I overpaid. So that helps set the standard for there's going to be a back and forth process because no matter what kind of a case, what area, what settlement, defendants don't want to think they paid more than they needed to pay, and plaintiffs don't want to feel like they left money on the table. So psychologically, everyone's going to have to feel like they cut the best deal that they could. And we're starting to set that process up at the beginning by reminding them there's going to be a little bit of a back and forth as we go through it. So that's going to stop us here in terms of the opening. Just set the ground stage, be friendly. I should probably add this in today. Um, I have found that tone matters more than almost anything else. I can get away with saying a lot of stuff if I say it with a smile and a laugh. You know, it just doesn't matter. But if you come in like a train, it's not going to sit as well. And I think if you've read some of the things about how people communicate, you'll find out that 7% of communication is the words we say. I'm gonna mess up my odds now, 38% is the tone, and 55% is the body language. So, if you wonder why, why does Zoom work and telephone mediations don't, it's because you can pick up on the body language, and you can see the context of how someone's saying it much differently in a telephone call. Obviously, you can't. So if you say things with a smile, hey, I'm going to be pushing you guys, it comes across much better than, yeah, I'm going to be shoving this down your throat later on, or I'm going to push us. That's aggressive, but hey, I'm going to push you. I'm going to ask you some tough questions. Okay. Now we can get that rolling with it. So starting it off as a friendly tone, warning them of what's going to happen, asking them some questions about it. What's your biggest concern? For the professionals, you can always ask them, hey, what are your thoughts on it? For those of us that deal with insurance matters, the adjusters sometimes are pretty bright and then they're ignored. Get them involved. Hey, what are your thoughts? Some of them are ecstatic to have somebody actually care what they think about the case. Now, some of them don't ever want to say a word, and you'll pick up on that and go, you don't have to answer. It's okay. Don't put somebody on the spot who doesn't want to talk, but give them a chance because human beings all want to be heard. So give them a chance to do that. Let them feel like they're involved. And then later on, when you're trying to get something from them or find out, what authority do they really have? Where are they really willing to go? Are they going to be able to call for more? Do they have the ability to make decisions on their own, or more or less make decisions by saying, yeah, I'm going to go recommend it, and they will generally follow my recommendations? That's how you've built that foundation for them early on and throughout by engaging with them. All right. So the difficult attorneys, and I am really looking forward to the end of this, what other people here have to say about working with the most difficult personalities and attorneys. Because I have found this is the biggest challenge. How do we deal with the attorney who just doesn't think they can lose, or even the individual thinks they can't lose, or the ones who don't want to admit there's any weakness, anything wrong with their case? What's the best way? Because that can get really frustrating. There's no give, there's no movement, there's nothing wrong. They want the other side to give in on everything, which of course is not going to happen because people like reciprocity. How do you deal with it? So I will give you guys my best thoughts. I will tell you this happened to me yesterday, and I'm still frustrated and chewing that case over in my mind about how I could have done it differently. These types of people come in three different types. They don't know what they don't know, or they don't know things and they don't know that they don't know it. That can be a challenge. They might be inexperienced or simply constrained. and they may act, weak when they're strong or strong when they're weak. And we'll touch on all of those in a few minutes. Um, so some of the things we've dealt with is one, having some patience. If you have a super strong um, personality, if you know any kind of different negotiating types, these are the aggressive people. They're competitive. They like to win, and they like to know that they're going to win. And I don't see that as a bad thing because that is my default. I wanted to win, and I wanted to make sure you darn well knew it. I'm going to come at you like a train. It's not always the best way to handle it, but that's the default personality type. Um, so those people want to be heard. So when you're talking with them, shut up. Let them ramble forever at the beginning. Then you're going to put a limit on it because you'll never get anywhere if you don't put a lid on it eventually. But let them be heard. And then critically, not only let them go, but make sure you can repeat it back to them, paraphrase it back to them, or summarize it. So far, what I'm hearing from you is this, and list as many points as you can, 8, 9, 10 points. Go through as much as you can. They'll let you know if you missed anything when you're done. They'll say, well, there's also this and this. So they'll go, all right, well, that's about right. Now they felt that you've heard them. Then and only then will you maybe have a chance to start working through some of the problems with them. But if they don't feel heard, not happening. They're just not going to budge or concede anything until you've given them a chance to do it. And then some questions for them. The strongest personality types, we like to be in control. Well, what happens at trial? You don't have the control anymore. So, I'm going to pop something up here that hopefully will help. So, make this a little larger. The number one driver of all decisions in human beings is loss aversion. We can circle back to that, but every psychological study will tell you that fear of loss is the biggest driver of decisions. And we all value what we have more than getting something of equivalent value. It's just human nature. We all do it. So for the real strong personalities, if this case goes to trial, what can you not control? Or a similar way, it sounds like no matter what the jury pool is, you can be in control at trial. Because it lets them start thinking through like, hey, I don't have control. And I can't pretend that I do, and I can't predict it. And that's an uncomfortable thing for someone who likes to be in control. For the detail people, what are the pros and the cons? The data collectors in our universe, they're going to be slower decision makers. They're going to be very thoughtful. Time to them is a chance to think. Their fear is being wrong, and they will not make a decision if they don't have the information. So let them collect it all, let them think. So when you're running into the people like, I don't know what I don't know, you ask them what the pros or cons are, they're going to have a hard time because now they got to think through it, but they want to make sure they got it right. So they're going to go through it. Now, the aggressive people are just going to pretend that they know everything. So that's not the best question for them because there are no cons. It's all good. Really. If it was that simple, we wouldn't be here now. But you can work through it. But what do you not control is such a good question for them. Within the rules of evidence, what's the worst thing the other side can say about your case? Another one that makes them start considering some of the challenges they have. Now, when you've got the inexperienced attorneys, they're going to have constraints they don't know. I don't mind dealing with them because at least then they'll admit when they don't know stuff. They're open to listening. So for those, you can often say, hey, this is my understanding of the law in this area. This is my understanding. This is my experience, what it's been. And they'll consider it. And then you have to give them a chance to talk with their client. Of course, you always want to do it in a way that does not embarrass them in front of their clients. So, one of the beauties of Zoom is it's easy to pull people aside. pull them aside and just talk to them directly. Hey, can I just talk to the attorneys for a second, or your counsel, or even, grab your cell phone when you're in a break and just give them a quick call. All good things to do it so you can kind of talk with them a little bit. But it can be tough. If they've got constraints, you just have to accept that and then lay the foundation for them to write their reports afterwards, right? I mean, if anyone's done liability cases or any kind of, situation where an attorney's hired by an outside firm where they get hundreds of cases, what's their biggest fear? They screw the case up and they don't lose this case. They lose the next 100 cases that could be going to them and is now going to some other law firm. So what do they do when the case is approaching trial and it hasn't settled? They write a letter to their client saying, here's what your exposure is, right? If trial does not go well, here's what a verdict could be, because they want to be able to warn their client in case things don't go well. Help them write that letter. Give them the ammunition. Let the adjuster who's going to get that letter hear directly from you as the mediator what some of those challenges could be. So when the attorney writes it, it's got backup. Ask them, and I usually would say like, hey, you don't have to answer it for me, but like, what are you going to say the exposure is in this case when you write your letter before trial? Or maybe they've already done it. What are you going to say the worst day in court is? Let them get it, because usually you'll have some sense that whatever that particular defendant's offering is pretty far south of where the high end of the verdict range could be. So put that out there. Let them write that letter, and then they can use that to help get some more money on it if that's what it's going to take. Now, if the plaintiff in that situation's in, somewhere around the orbit of Mars with their demands, it's probably not worth doing that, because it doesn't matter. Plaintiff wants everything under the sun. They want their best day in court. You need to get them into a range where you can at least start seeing the potential for resolving it. If you have experience with the people involved and know the supervisors, with permission of the attorneys there, it's okay to reach out to their bosses sometimes. I have done that in a few limited situations, usually after mediation, where I'll call up the supervising partner and say, hey, can you take a look at this file, please? Maybe tell me what I'm missing here. I might be missing something. Tell me what it is. Let them get a look at it to see like, okay, maybe this is not as good a case as we thought. Because that you don't want to let the inexperienced attorney drive a plane into the ground that doesn't need to be. And at the end of the day, if they're willing to take that risk, there's nothing you can do. We're not paying more than this. We aren't taking less than this. Okay. What happens if it goes south? We're happy with that. We'll take that chance. Fine. They've made an educated decision. If they've been able to tell you what the weaknesses in their case are, and they're still willing to do it, that's great. That's an okay thing to handle. Other questions that work for some of these people are, what is your biggest hurdle at trial? Very similar within the rules of evidence. What's the worst thing the other side can say about your case? I've found that what are your biggest hurdles at trial tends to get more information than what's the worst the other side can say about your case. Because the biggest hurdles, they'll just start listing them out. They'll give you a bunch of them, and then all of a sudden you're like, okay, so what are we going to do about those? And how are we factoring those in towards finding a middle ground here that could resolve this case? One of my friends brought something up the other day that, a particular party had some pretty good evidence on an issue, which the other side had, but no one was mentioning it. And then in the private caucus, the side that had this solid piece of, it was a particular picture, says, here's why we're at this thing. We've got this picture here. And I'm like, well, do they have it? Yeah. But don't mention it to them. Well, how are they supposed to evaluate it if they haven't seen it or no one's discussing it with them? You want them to take a big discount off this case because of it, and it kind of makes sense, but you don't want me to mention it to them. How are we going to make that happen? So don't be afraid to ask them about that. Sometimes people want to hold things back for trial, their judgment call on it. But if they want the case, they have to decide, do they want this case to settle in the range they think makes sense, or do they want to just not settle it and take it to trial, but it's hard to do both without addressing the pitfalls and the real issues that you think the other side has to deal with. Before I jump into the strong as weak stuff, as you approach an impasse, a few questions that can often be helpful for you. And if you guys reach out, I'm happy to send some of these out to you guys afterwards. I just keep a running list of questions. What about this does not work for you? You're going to find out then what it is that they really want or need to settle the case. That's usually it opens up doors that weren't discussed before, but are often driving it. And for those of you guys know these things, some of these are kind of the no-oriented questions. And they're phrased particularly this way. What are you giving up by not settling? That gets back to our loss aversion, right? People tend to focus on what they're not getting. Hey, I wanted $1 million and they're only offering 300. All right, well, out of that 300 after your fees, how much are you going to get? What can you do with that money? Can you buy a house, a car, a college fund for your kids or grandkids, whatever it happens to be on it? That starts getting to look at what they're giving up by settling, as opposed to simply, I'm not getting what I want or I'm paying too much. All right, well, you have to pay too much to settle it, but what are you giving up by that? Well, shoot, I'm going to give up another couple, 100,000 in fees to try it. And I'm going to give up the chance that it could be way more a trial. And the fact that I got to go sit in court for a week. All of those things are things that they are losing with that can get them to recognize the upside to settling within that. If someone does not want to discuss anything, are you against providing greater clarity? I have never had anybody go, yeah, I am. They will always give you something with that. And then when I'm following up with people afterwards in mediation, if it's been several months and nothing's gotten done, this is the email I send them. It's literally in the subject line. It's got the case name, plaintiff versus defendant, dash, have you given up on settling? And that's it. The number of people who get that email and don't respond is almost non-existent. If they don't respond, they have given up on settling. Otherwise, they will always get back to you on it. And it's a great way to reopen things. So strong is weak, weak is strong. I don't know how many people here have played poker, but it's a poker term. If you see someone who's at the poker table and they put all their chips in the middle of the table and they are staring you down and they are glaring at you and they're challenging you to call them, they're usually bluffing because they don't want you to call. So they're trying to scare you into not doing it. Conversely, person who puts all their chips into the middle of the table, leans back, is chatting with everybody, is getting a drink from the cocktail person coming around, chit-chatting with their friends over at the other thing, they've got a good hand. They want you to call. So one of the things I've seen now in mediation is almost without fail, it's the same thing. The attorneys who come in and are just way too strong, have nothing wrong with their case, even though they obviously do. They're trying to, and they usually anchor a super high number or a super low number and stick to it for a while. They either demand the sun, moon, and stars or offer next to nothing for several go back and forth rounds. They're going to settle that case and they're going to crack at some point. And you just need to have the patience. You need to let the others say, no, look, have patience. They're digging their heels in. It's not really adding up right now. Often when this happens, they're just trying to cut the best deal they can. And if I was advising somebody, as a negotiation tactic would be not to do this. Because when you stick too strong for a while and then all of a sudden you crack and you make a big move and then another big move and another big move, it doesn't take somebody real smart on the other side to recognize they're just going to keep moving now. I don't have to do much more. They're going to just keep coming towards me no matter what. So, that strong is weak, weak is strong. Obviously, it works in reverse as well. The person who's just like, yeah, I've got this problem, and I know, and I'm all right. And yes, they make a concessions. They don't sit there and go crazy with their things. They're pretty confident. And they're going to draw a line at some point and they're going to mean it and they're not going to be upset because they felt like, hey, I've recognized it. I know what my options are. I know what my best alternative to settling this case is, and I'm comfortable with it. And those are the ones that should worry the other side. And I'll give you an easy example. I was 20, 25 years ago, I took over a case and it was a plaintiff's personal injury case. And I didn't know anything about it. I go do a deposition of one of the doctors, and the other attorney goes over to me and goes, "Hey, Mark, have you seen the surveillance video yet?" And I go, "No, not yet." And he goes, "Take a look at it. Maybe you can come up with a way around it. I haven't seen one yet, but if you still want it, my client will put their proposal for settlement back on the table." And he was so nice about it and real mellow and admitted, "Look, if you come around, let me know. I'll talk to my client." That wasn't a good sign. And sure enough, the tape was ridiculous. I mean, there was no possibility on God's green earth, short of like an insane miracle, that we were going to ever win this case, because what was on the videotape and what was in the other parts of our evidence were diametrically opposed. But his approach was so mellow, it wasn't overpowering, it wasn't being difficult, that I was real nervous about it. And sure enough, week was strong because he was just so laid back with it. So if you see that in a mediation, recognize it, coach the other side a little bit, and let them know. Generally, just if they're strong, have some patience. If they're weak, guys, they're pretty confident in their case. They know there's like this weakness and that weakness. They acknowledge it. They're okay. Like, how are we going to get around some of their strengths and your weaknesses? Because if you want to settle this thing, it's going to take something close to that. And you'll be okay. But critically, don't get bogged down by somebody acting too strong. Have a little patience. They will generally crack towards the end. And if they don't, okay, you spent an extra 45 minutes. Maybe you didn't need to, but at least you know for sure that this case is unsettling. Dealing with some of the people, the ones who can't lose, any of that stuff, I'm looking forward to your questions, because as I said, I find that to be the biggest challenge for me, and I still struggle with that a lot. Okay, best practices. I am constantly surprised by how many mediators do not have DocuSign or one of the equivalent programs out there just to settle it. I literally whatever the word is. I'm just stunned. First, the rules of procedure require that a mediation agreement be written and signed. So if you're doing it by video, I don't know how else you're going to get that done. I mean, I guess people can print and scan it, but it's going to be hard for a lot of people to do that, don't have literally the infrastructure to set it up. And the rules of mediations allow us to assist with memorializing the agreement. Now, I know there's a lot of people that feel like we're not supposed to, help write settlement agreements, that it's bordering on giving legal advice. For what it's worth, I just completely disagree. If you've been practicing long enough, you understand what generally needs to go into it. It is not the full release they're going to sign, but it's the outline of it. It's the material terms. In many cases, these are almost the same in every one. I mean, we've got templates, and I'm happy to share them for first-party cases and personal injury cases, because it's pretty straightforward. The outline of them are the same. I mean, maybe there's confidentiality, maybe there's not. Otherwise, guess what? Plaintiff's gonna have to satisfy all the medical bills. It's not rocket science. And we are service providers from a business perspective. Clients want to make sure these things don't unravel. And everybody who's practiced or done a lot of it know what's the one way to make sure that a case is going to unravel? Don't get a signature before everybody leaves. So have those templates. Spend $15 a month for a DocuSign account or whatever the heck it is. DocuSign, I find, is the easiest one for the users who aren't technically comfortable to do, but there's 100 of them out there. And have them ready, and then you prepare the written thing. If someone has it with them, I'm ecstatic. I ask every attorney to bring their documents, releases with them. If 1 in 100 do, I'd be surprised. So fine, I'll use my template, show it to both sides, make sure the attorneys agree, and then get everyone to sign it. The rules have been changed. The attorneys no longer have to sign the agreement. I always put their lines in there. I rarely get pushback. I think the attorneys like it that they're signing and their client is, so there's no, if they have if their client has a question later, but what was agreed to? Oh, no, no, no. We both signed this. We both saw the same thing. It helps the attorneys with their clients a little bit. But they almost never refuse to do it. And then it's set. It's hard to wiggle out of it. Once someone signed it both legally and psychologically, they are bound to it. Now, tell you a bad story that happened, which is the rules will allow you to, electronically record it as a way of memorializing the agreement. Right after COVID hit, as we're all kind of figuring this stuff out, and I didn't have the software yet to do the DocuSign, or I did but didn't know it. We had a particularly contentious one that settled, and we by agreement we all turned on the video recording, went through the terms of the settlement, everyone agreed to it. And 2 months later, they still hadn't had it done because one person was trying to pull out, even though she was on video agreeing to it. And the moral of that story is, for reasons that psychologists could probably tell you, but I have no clue, someone's signature seems to carry more weight with them than having their own voice going, yes, I agree to all of this. Okay. Get it done in writing. And have that stuff. It's both good from a business perspective and also getting certainty to it, and getting the attorneys like it. Everyone's happy that they get it done. And you can walk almost anybody through it all. The Electronic Signature Act, yes. If you're not familiar with 668.50, the short version is that your electronic signature, if it can be verified, is binding on you in Florida, just as if you wet signed it with a pen and paper. Your email address should be unique. You can use, at least with DocuSign, you can send it to their cell phones. Pretty good clue that it's going to be them signing it. And just as good as when we did it in person, because at the end of the day, I mean, someone says they are John Smith. I'm not asking their driver's license. So if they sign it, it turns out not to be John Smith, fine. That 1 in 100,000 case, they can unwind that later. But you get someone's email or telephone number assigned to that, works pretty well. And I don't think I had any of those unwind afterwards. I do suggest to the attorneys as we go through the outline of it, guys, this isn't the final thing. Let's not over lawyer this. Because if you let the attorney, I don't email it to them to review. I do it on screen, because if you email it to them to review, the attorney brain kicks in. They all start wanting to get too detailed. It becomes 85% of what the ultimate release is going to be. It'll take 2 more hours to get done, and it might unravel it all. So my suggestion is have a simple template, 1 or 2 pages, and show it to the attorneys. Get all the essential terms. If they need confidentiality, pop it in there. The mutual release will include confidentiality, hold harmless and indemnification, mutual non-disparagement, things of that nature. They can work out those details afterwards, but as long as it's in there, they're going to feel like they're bound, and everyone's going to go forward afterwards. At this point, I don't know, Megan, I think Megan was right. Megan, do we have questions and things that you want me to address?
We do. We have 2 questions from one of our attendees, Asha Thomas. The first question is, what's your advice for when you see an attorney is dominating the room in a way that limits the client's voice, and how do you, if at all, rebalance without appearing to undermine counsel?
Great question. And that can be hard to do. 2 ways that happens. If it happens in opening, I generally just try to cut that off. I tell people, look, my experience has been rebuttal. It generally is counterproductive. I won't prevent you from doing it, but I generally don't find it helpful. Very rarely, if the attorneys are just starting to devolve, one of the beauties of Zoom is I can just open those breakout rooms back up again, and it forces them back into it, and that ends the problem. They may not be happy with me about it, but it's better than letting the whole thing fall apart. And for the most part, they generally know. So I will do that. In terms of handling them in like a caucus with their client, um, the one time it's super hard is if there's a language barrier and they don't have an interpreter in there. At that point, I only speak English. There's not much I can do. I mean, you can tell when the attorney isn't fully translating or interpreting stuff well. There's not a whole lot you can do. Um, there are times if you're comfortable, you can ask the attorney directly, hey, how does this, is this going to be in the best interest of your client to leave this out there? And you're really just reminding them that, it may not be about what they want. It might be about what their client needs. Um, and I'm not hesitant about doing that. It's definitely a little scary because you might hit them the wrong way with it, but at the end of the day, that's their job. Another way to do is, well, what are your client's thoughts on this? And if someone speaks English and, they're not saying anything, sometimes they don't want to. And I'm not going to make somebody talk who's scared. And I'll circle back to that in a minute, but I'll just, I'll ask them directly, hey, Mr. Williams, what are your thoughts on this? How do you feel about it? You know, let them talk a little bit. Sometimes it happens with husbands and wives and only one of them's talking. We'll do the same thing. The attorney's pushing out, say, hey, do you mind if I just ask your client directly? Everything, it's still confidential within here. Most of the time they will. If they absolutely refuse, that's when I'll pull them aside later on and say, guys, like, what are you worried about? And you can always say, look, if you're afraid of having them talk to me here where it's confidential, how are you putting them on the witness stand at trial? Because that's the problem, and that's why you don't see it too often with more experienced attorneys. Now, if a person doesn't want to say anything, it's a similar issue, which is, if they're uncomfortable talking here, how can they go into court and do this? That's a hard thing. Same thing if I see somebody in their car. First of all, I will not let somebody mediate if they are driving a car. It's one of my few rules. If they are in their car driving, it will not happen. They need to pull over. I will push them pretty hard to find a place that's comfortable. It's a guarantee that they were not told by their attorney that mediation is going to last more than 20 minutes, and they're not going to get whatever it is they want as the result and that quickly. Because you'll say to them, "You get a place you're going to be comfortable for the next 3 or 4 hours?" Huh? Yeah. It's also a sign of attorney of like, look, hey, if they can't take a couple hours off of work for this, how are they taking a week off for trial? That's another aspect. If you have high earners, doctors, as a principal in a case, hey, how much money are you losing by not practicing medicine for that week of trial? Judge isn't going to tell you when it is either. You're going to go in when the judge says, and you're going to be canceling your appointments. And if they're a surgeon or, an anesthesiologist and you're within $50,000 of a settlement, they're going to lose 50 grand just not, doing their job during that week. So, getting them to focus on that can be a way to do it. But to answer your question, the bottom line is I ask the people directly. And, if an attorney absolutely refuses, there's only so much you can do about it. That's between them and their client. And if you pushed all the times and asked the attorney if it's in their best interest and, how are they going to handle a trial? You're at the limit of what you can do. What other questions do we have, Megan?
There was, well, you answered really her second question, which was great because your answer was so thorough. But there was one more that she said, are there any other specific phrases that you find effective in redirecting an attorney who's escalating conflict without shutting them down? Because she said this happens a lot in her family mediations.
Yeah, family can be a whole different, and that's a fair point. I do mostly civil cases. I do a few family cases, but those are almost always when I have friends who are needing a little assistance. If they're escalating it and in family law generally, you're not going to do a joint opening. I'll be honest, I'm going to let them go for a while. They need to get it out and vent it. Let them get it out. And then eventually, if they do it a few times, then you need to put some brakes on it. One of my friends who's a family law mediator had a great line for that situation, which is after a day of people griping about how it's not about the money, it's what's right, it's not about the money. Finally, he just goes, you keep telling me it's not about the money, but what is it that you're asking for more of? And the issue ended immediately. Just shut it down. And when I did something similar, we had a business divorce. And, as usual in a business divorce, and if you guys have done them, this is what happens. couple of partners. Every one of them was the most responsible for the business, and the other ones had nothing to do with it. It was all them. Um, and after about 8 hours of hearing about this from one person, I got fed up, and candidly, I said it out of emotion, which is the dumbest way to handle it. And I just got lucky. You know, he was going on and on. I said, you keep telling me that you did it all. He did nothing. So you don't need a non-compete, do you? Oh, Terry goes, yeah, we need one. Okay. And it stopped. I never had to hear about who was most responsible for the rest of the time. Um, so you got to challenge that head on, but you definitely need to let's get it out. And then the other ways you can handle saying, hey, it sounds really unfair that, you know, your spouse can have six affairs and there's nothing you can, there's no upside to it financially. Don't be, let them hear that, right? Because you could see how that feels. Like, they can sleep with half the county. Doesn't really change alimony or child support in a family law case unless they wasted assets doing it. But how do you not acknowledge that that just is a cruddy feeling on the other side of that coin? God, like it just must stink to hear that and recognize there's nothing you can do. Um, Other questions on how do you redirect things? How much of that is admissible is always a good one. You know, um, that's usually one of my little go-to things. Like, how much of that will the jury hear? Because all of a sudden, some individual people don't realize that. They just think what's important to them is what matters, and understandably so. Um,
Bringing it back to the issues, right?
yeah.
That's always a good way to bring people back to
Bringing it
the
back, but not ignoring the emotions. People like to say like, hey, separate the emotion from the problem. But what if the emotion is the problem? You have to be willing to work within that and let them get it. When they talk about it, paraphrase it back. Hey, sounds like, your spouse, they had six affairs and, they weren't real nice at home. And then if they weren't, they were working or traveling. And I'm trying to be very generic about it, but, feels like you were ignored, not valued, and cheated on, and it's tough. And then once they feel like they're understood, then you can kind of like, okay, how are we going to handle that? How much of that's going to change the outcome in court? What else, guys?
Well, we did have one other question about whether you would share your outline with our attendees today.
The outline, you mean the one I've handwritten all over? Yes, I'm happy to share, some of the questions that I've gotten here. I'm happy to send that out. And I don't know, Megan, I'll send it to you or however we're supposed to do it. There's nothing that we do that's really secret. I'm happy to share, some of the summaries and things that we use. Take feedback on them. They're evolving, the outlines for settlements, same things, have those ready. Happy to share any of those. As other people have shared with me, mediator's proposal, I use John Salmon's letter. I think that's a lot of people have seen that. Have not. I'm happy to send that out to you because he's got a great template for mediators proposals. And I
Sure.
99% cut and paste that every time.
So let's do this. Mark, send me your materials, and then anyone who's interested can reach out to flabaradr@gmail.com, and we'll make sure that you get it. It may take some time. I may wait until I get a couple of inquiries, and then I'll send it all out at once. But we'll do it that way. So I'll await those materials from Mark, and then we'll make sure that we get it out to anyone who's interested. Somebody did ask, can you go over what templates or quick agreements you keep nearby when mediating?
Um, I don't know that I keep them nearby. We just have a standard forms that I can grab, and we have it, for each case, we already have them generally with the parties' names filled in already, in a Word document. Obviously, I edit that as necessary. If different people show up than expected, sometimes the attorneys aren't the same or whatever. Just, plug and play with it. But, it's like, defendant agrees to pay, plaintiff agrees to accept blank amount and full and final settlement, and kind of just go from there. It's not, it's literally a page long plus room for their signatures. It does say the material and binding terms are, I put that in there hoping that makes it harder for them to wiggle out later. No one's ever
Yeah.
challenged it yet, so we'll see how it plays out. Um, what else, Megan?
Well, I think those are the questions on your topic today. So thank you, Mark, for this excellent presentation, and to all of you for participating in this webinar provided by the Alternative Dispute Resolution section. Today, we had how to start and finish strong in mediation with Mark Greenberg. That is what you're going to need to report for your CME credit. On that mediator reporting form, you're going to need to have the title and Mark's name, and this is good for 1 hour of your CME credit. The CLE number for this program is 260206-4N, and it qualifies for one general CLE and one ethics CLE. We hope that you found this program insightful, and we hope to see you at future events. Coming up, we have our mediator forums. Those are on the first Friday of every month at 8 a.m. We also have our arbitration forums. Those are the second Tuesday of every month at 8 a.m. They are open to all, not just members of the section, and they are free to attend on Zoom. Our next Lunch and Learn is May 8th. Actually, if you scroll all the way up in the comments, I put the link to the registration forms for May and June. And then we also have our dispute resolution mixers happening in person over the next few weeks. So if you check out our website and calendar, you'll see what cities we are in next. I think we've got Tampa, Orlando, Miami, and Fort Lauderdale. So we invite you to join the ADR section to receive access to more quality CLE courses and the latest news on dispute resolution processes. Thank you again to our annual section sponsors, Miles Mediation and ADR Notable. Thank you, Mark, and thank you for being with us today.
Thanks, guys.